they are simply making a kind of stab at deciding who should be invited to make oral presentations and who should not. It's entirely unfair, it's entirely irrational and unreasonable.
Private property rights are under threat around the world. The idea of the Great Reset is gaining popular traction. And here in South Africa, there are two processes currently before Parliament, the Expropriation Bill and the Constitutional Amendment Bill, which could threaten private property rights in general. Anthea Jeffery, who's a senior researcher and policy analyst at the Institute of Race Relations, joins us back on the CRA channel to discuss these two processes. Anthea, in your view, what are some of the procedural flaws that have characterized this constitutional review process as well as the EWC bill?
Well, there are two bills which, as you say, are going through the parliamentary process. The one is the Constitutional Amendment Bill, which we might call the EWC bill, because it will allow expropriation without compensation. It will change Section 25, which is a property clause in the Bill of Rights, in order to achieve that. And the second is the Expropriation Bill, which does make provision for EWC2. There is a clause allowing for nil compensation to be paid where this is just and equitable. But it also tries to create the impression that in most instances there will be some measure of compensation to be paid. But that Expropriation Bill is nevertheless tremendously worrying, partly because it does allow nil compensation in a broad range of uncertain circumstances. Secondly, because it skews all the expropriation procedures in the state's favor and against the owner. And third, because it has a very narrow definition of expropriation, which can lead us into all sorts of negative consequences for the economy. But coming back, we've got two bills, two processes, and both of those processes are deeply flawed. And they show that though the government is supposed to really facilitate proper public participation in the legislative process, this is not being done. Moreover, it's not just the government that has an obligation to do it. The Constitution says that Parliament and all its committees must facilitate public involvement in the legislative process. And it's been therefore accepted that when a bill is wending its way through the legislative process, there should be written submissions. And those who make written submissions should have the opportunity also to be able to ask to make oral submissions, oral presentations to the committee in Parliament, so that they can elaborate on their concerns and members of Parliament can engage with them directly. And it's that particular part of the process which has gone very wrong on these two bills. But there's a deeper series of problems which just show that Parliament is not taking public participation seriously. So on the Constitutional Amendment Bill, the deadline for written submissions was the end of February 2020, just before the lockdown began. And they've received something like 204,000 submissions, according to information that's recently come out from the ad hoc committee busy dealing with that bill. They obviously haven't had time since they started working again towards the end of last year to look at those 204,000 submissions. So they are simply making a kind of stab at deciding who should be invited to make oral presentations and who should not. It's entirely unfair, it's entirely irrational and unreasonable. The IRR happens to be one of the organizations that asked to make an oral presentation, but was not invited to do so. And there must be very many other organizations in the same position. So it shows that the ad hoc committee, for one, is not taking its public participation obligation seriously. And the same phenomenon is evident with the Expropriation Bill, which is being dealt with by another committee. This is the Portfolio Committee on Public Works and Infrastructure, which received about 90,000 written submissions on the Expropriation Bill by the end of February this year, and was also supposed to give an opportunity to make oral presentations to all who asked to do that. But again, because it didn't go through the 90,000 submissions, it really had not much idea who'd asked. So it made its own choice as to who should be invited to come. And again, it's a highly arbitrary and unsatisfactory process.
Anthea, could you comment on the socioeconomic impact assessments and the importance of that process as part of the overall due procedure that is required in terms of legislation in South Africa?
Changing the constitution to allow expropriation without compensation, and then coming up with further ordinary legislation which facilitates that process. The government is striking at the very heart of what underpins the free market economy, what makes for prosperity in any country. And these are changes which need to be addressed with the most scrupulous care, with a great deal of attention to what ordinary people say, and particularly with proper assessments by economists of what the likely socioeconomic impact is going to be. Ordinary people need that kind of information made available to them. And the Constitutional Court has indicated that ordinary people have a right to know about the issues. So going right back to the beginning, there should have been a proper socioeconomic impact assessment of the Constitutional Amendment Bill, of the Expropriation Bill. Those final reports should have been attached to the bills so as to help inform people so that they could more easily make submissions on those two bills with a proper understanding of their ramifications. Then all of their written submissions should have been properly considered, read at the very least by committee members and properly considered. Then there should have been a proper choice of those who asked to make oral presentations and enough time set aside to allow them to do so. Instead, there's just a major rush. The committees want to deal with these things as quickly as possible. They have deadlines in their mind. They're ignoring what the Constitutional Court has said, which is that the right to public participation in the legislative process is more important than any timetable, and it's the timetable that must yield to the right and not the other way around.
So Anthea, as you've laid out, it seems that Parliament has not followed due process in terms of the Expropriation Bill and also the Constitutional Amendment Bill. Do you think that this opens Parliament up to some kind of legal challenge?
Absolutely. The Constitutional Court on a number of occasions has struck down legislation that has already been adopted by Parliament because of a failure to facilitate public involvement in the legislative process. The Constitutional Court takes that right very seriously. It's indicated that people must be given an adequate opportunity to know about the issues, an adequate opportunity to have their voices heard. And so when Parliament shortcuts the process in the way that has been done by both of these committees, it certainly opens up the opportunity to have both bills set aside for failing to comply with very clear guidelines laid down by the Constitutional Court.
So Anthea, you wrote an article which we'll link to in the description below on the Daily Friend online newspaper, where you said that it's time for a great reset in terms of South Africa's approach to public participation in the EWC debate. Could you elaborate on that for our viewers?
We need a great reset in terms of everything that's been done on these two bills so far. We really need to go back to the beginning. Recognize also that our economy now is really on its knees, that it was in a bad enough situation before the COVID lockdowns. But now with COVID, we've had this extraordinary contraction in GDP, major rise in debt, and so on. And so it makes it all the more urgent that there should now be a proper socioeconomic impact assessment. People must know what these two bills are likely to do to the economy as we struggle to come out of all the damage that has been done by COVID lockdown, which of course has not yet ended. There are going to be further probably lockdown steps taken in the future to deal with future waves. So it might have been one thing to consider expropriation without compensation before the COVID pandemic. It's a very different thing to do so now. We must have a proper socioeconomic impact assessment. It must be made available to people. And then we must have a proper process of public participation where all the written submissions that are made are properly considered, where people who have something important to say to Parliament are given the opportunity to make oral presentations, and where it's a carefully considered process, not just a sort of rushed and botched job by legislators in a hurry to do what the ruling party has indicated it wants done. All the South Africans who have finally managed to start obtaining property ownership. We have 7.8 million Black South Africans who own their own homes, often without formal title deeds. What they most need is formal title deeds, not a very real risk that some inept and bankrupt municipality will expropriate their house from them for little or no compensation.
Well, thanks very much, Anthea. If you enjoyed this analysis, please give this video a like and also leave your thoughts in the comment section below. Why do you think that public participation is not being adhered to in this EWC legislative process? My name is David Ansara. This is the Center for Risk Analysis. Until next time, take care.